Anything else that either side wishes to say?
No, Your
Honor. I'm going to allow the experts to review it. They will have to report back to the court with a supplemental report no later than 6 p.m. tomorrow night, so that the state will have an opportunity, one, and they'll have to set themselves up at the state's convenience to be interviewed if it changes any of their underlying opinions as to the ultimate issue in this case. And then two, the state can take whatever means necessary to get a rebuttal expert if they feel that it's necessary. I think a lot of this can be dealt with on cross-examination, that, showing what their real opinion was at one time and how it's suddenly changed, even though the evidence or the information's been there for 4 years, and why are you just now changing your opinion? And cross-examination can go a long way to.
I mean, David looked at it. We certainly don't anticipate a change of opinion, but I can certainly tell them that. I'll tell you that the journal is about 250 typewritten pages.
They better get busy.
So I can.
They better get busy, and I hope they're speed readers.
I'll email right now.
All right.
Judge, just to be clear, with respect to Dr. Wood, since her opinion is only as to the mental illness, because she deferred the opinion on.
We'll see what she says, and then we'll address it. But I mean, again, there's a lot of things that can be dealt with in cross-examination, because she clearly said that. Clearly brought up that I just now provided this information. She may even say I don't have time to do it and not give an opinion. But I mean, the 703 does allow, again, I think the spirit of the rules have certainly not been followed, but it does allow information at, before, during the hearing. They're on a strict guideline, timetable.
Thank you. State's position, though, is Dr. Wood has deferred an opinion about insanity, and that she should not be allowed to go back.
I'll have to read her whole report. I did read that, okay? But let me go back and read her whole report. Does she explain why she deferred to them? Because she didn't have,
Judge, and the state's going to step off in it if they keep this up, because what she's going to say is, number one, she did give an opinion on insanity. It's in her report. She fully gave an opinion. She deferred purely because of the competency issue, because that required inpatient treatment.
Okay, I will read the report.
If they want to get into that, we can get into that.
And we disagree with that, John.
Okay, I'll read it, and we can maybe talk about it more at lunch as to what opinion, if any, she's going to be allowed to give. Let's get the jury in here. Sorry for a little bit of the slow start. First day can always be kind of rough, because particularly in a situation like this, you got a lot of procedural things you need to address and this type of thing. So I appreciate your patience. I know it's just the first day, but how are the hotel accommodations? All right. You want to stay an extra week or two just in case? Okay. Oh, well, just testing the waters. Before we start with anything, Mr. Glenn Funk is back with us. He has gotten a full clearance from his doctor. He is totally healthy, not contagious, not infectious, no problems whatsoever. And certainly he wanted to be here for the trial of this case, and I just asked him to do everything I could to make sure that his doctor felt he was healthy enough to be here. He went to his doctor this morning, and the doctor has given him a full clearance and everything is safe, but the doctor did say just continue to wearing a mask, so he's going to be the one person for sure at the council table for the present time to be masked, okay? Please don't think anything about it. Everything's good to go there. The next thing I need to do is ask you to please stand and raise your right hand. We'll swear you in as the jury on the trial of this particular case.
Do you solemnly swear or affirm that you will justly decide the questions submitted to you, that unless you're discharged by the court in further deliberation, you will render a fair and impartial verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God? All right, you may be seated.
Just a couple other things as this trial unfolds. When you come into the courtroom, please be seated. You don't have to stand. We're standing for you. You're the judges of the facts in this case, and you're going to ultimately become the judges of the law under my direction. But you are pretty much the judges. You're the ones that are wearing the robes, and we're standing in respect to you. So when you come in, please just be seated. You don't have to stand and wait for everybody to be seated, all right? Before we start the actual trial, I mentioned to you last week that I was going to go over some additional things as it relates to the trial procedure and things of this nature, just so you have some insight as to how this case will actually unfold. As I indicated to you last week, and it was brought to your attention several weeks, this is the state of Tennessee versus Travis Reinking. Mr. Reinking is charged with 8 counts of first-degree murder, 4 being by premeditated murder and 4 being by felony murder. Now, also, as I indicated to you last week, these are alternative theories of the same offense. There are alleged to have been 4 homicide victims. So when you begin your deliberations, you will be required to render a verdict as to each theory. So, and you can find Mr. Reinking guilty of all of them, not guilty of all of them, guilty of some, not guilty of others. But the point is that you will have to render a verdict as to each of those 8 counts of first-degree homicide or any lesser included offense that I charge you. He is also charged with 4 counts of attempt to commit first-degree murder and 4 counts of employment of a firearm during the commission of a dangerous felony. I will give you the detailed instructions on each of those at the end of the trial and the elements that we discussed last week, what makes up each of those crimes. Mr. Reinking is presumed innocent of all the charges against him, and that presumption remains with him throughout the trial of the case unless the state proves beyond a reasonable doubt unanimously to the satisfaction of the jury that he is guilty of one or more of the offenses with which he is charged. The indictment charging Mr. Reinking with these crimes are not evidence against him and cannot be considered or used against him in any manner whatsoever. How that indictment issues is totally different than what brings us here today, and for you to ultimately decide. Different levels of proof, different types of proof, everything is totally different, and therefore it cannot be considered under any circumstances as evidence or be used against him in any manner whatsoever. Normally the first thing we do when we start a trial is jury selection. We spent 4 days last week accomplishing that, so we're beyond that point. Once the trial of this case will starts, the first thing that will occur is that one of the state's attorneys will get up and read the formal indictment to you that sets forth each of these 16 counts with which he is charged. The indictment basically contains the elements that are expected to be, that the state expects to prove during the course of this trial. Mr. Reinking will then enter his formal pleas of not guilty, I assume not guilty, as to each of the 16 counts. Once that is done, then we will proceed with opening statements. During opening statements, the attorneys will be given an opportunity to basically outline for you what they believe the evidence in this case will be and why that evidence, not arguments, but basically suggesting to you that that is the evidence they will rely on to support their respective positions of guilty or not guilty. It's just to give you a roadmap or some insight as to what this trial is all about, so that you can kind of get an idea of where the focus of things will go as they call witnesses and things of this nature. Since the state does have the burden of proving the guilt of the defendant beyond a reasonable doubt throughout most of these proceedings, the state's attorney will go first and then followed by defense counsel. Once the opening statements are concluded, we will begin the evidentiary portion of the trial. Again, as the state has a burden of proof, they obviously have to go first in putting on their proof to try and establish beyond a reasonable doubt the guilt of Mr. Reinking for each of these 16 counts that have been placed against him. The way that proceeds is the state will, the state calls each witness, one of the state's attorney will get up and ask that witness whatever they intend to ask that witness in direct examination. One of the defense counsel will be given an opportunity to cross-examine or challenge and confront the testimony of that particular witness. State's attorney will be given an opportunity to redirect if they feel it's necessary to maybe clarify some type of parts of the testimony that may have been challenged on cross-examination. If that happens, then the defense attorney will be given an opportunity to cross-examine, and this process will continue with each witness until both sides have asked and answered any and all questions they intend to ask of that witness. You have been previously, wasn't attached to their questionnaire, a list of all the witnesses, and you've indicated that you don't know any of them, but I think there were 62 witnesses. I'm not sure all 62 will be called to testify or not, but be that as it may, there could be a long list of witnesses to be called and testified, to testify. As we go through the process, and these witnesses are called, if you cannot hear a question asked by an attorney, or if you cannot hear an answer provided by a witness, please advise us immediately. It is absolutely imperative that you, as the sole judges of the facts in this case, be able to hear not only the answers given, because that's the evidence, but you have to be able to hear the questions so you can put the answers in context. And sometimes the questions can be, and I will instruct you how, can be considered a part of the evidence if it's a hypothetical type question, for example, and the witness agrees with it, then the question, the contents of that question can become evidence. But the important thing is that you hear both sides so that you fully understand, appreciate, and can evaluate the evidence as it's introduced. You do have notebooks and writing instruments to take down any notes that you wish to do, and please do that. As I said, this process will continue until each and every witness is called by the state. At the conclusion of the state's case in chief, whenever that may be, there will be a recess that will require to be taken, even if it's in the middle of the day. I told you that we would do everything possible to address issues either before trial, during lunch, or after trial, so as not to delay or your time here or waste your time here where you're just sitting and twiddling your thumbs or whatever the case may be. So we will try and deal with those issues, but one we just got to deal with as soon as the state's case in chief is concluded, and those are some motions and some legal issues that the court has to address with the attorneys. Once we have addressed those issues and we come back into the court, then the defense will put on any proof that the defendant intends to put on. Please keep in mind, as I've already told you, it is the state's responsibility to prove the guilt of the defendant beyond a reasonable doubt. The defendant has no responsibility to establish his innocence unless he enters a plea of not guilty by reason of insanity. Okay, that is a clear exception under the law. If he doesn't plead it, then he doesn't have to put on any proof whatsoever. But if he does plead not guilty by reason of insanity, then the burden of proof of the issue of insanity must be established by clear and convincing evidence by the defendant. Okay, it's a different situation where he is pleading insanity as a reason for being found not guilty versus just a general plea of not guilty. In fact, most offenses, the state still has the burden, but insanity is one which by law is placed upon the defendant to establish. So when we come back, if that's his plea, when we come back from that recess after the state's case in chief, then the defense will put on any and all proof the defense intends to put on during the course of this trial. And the procedure is the same as the state's case in chief, except for the roles of the parties will reverse, with the defense asking the questions and direct and redirect, the state's attorneys asking the questions and cross and recross. And this process will continue until any and all of the defense witnesses have been called and questioned. At the conclusion of the defense proof, there may be rebuttal proof by the state. In a case like this, certainly that will depend in part on what testimony is presented by the defendant. If that occurs, then we go back to the original process with the state asking the questions first and the defense asking questions and cross and recross. Once all of the evidence in this case has been presented, Then the attorneys will have an opportunity to address you in closing arguments. During closing arguments, the attorneys will spend time not only, one, to point to what they believe is the most critical evidence in terms of evaluating in order to render verdicts of guilty or not guilty. Obviously, you have to consider all of the evidence that is presented during the trial of this case, but certainly some evidence you may ultimately decide carries greater weight than other evidence, and they're going to argue what that evidence is. Also, during closing arguments, they will argue to you the law that exists in this case or will be presented to you in this case, and how that law applies to the evidence in this case to assist you and give you guidance in trying to help you render the verdicts. Obviously, they're going to argue from their respective sides. The state will argue how that evidence, when the law was applied to it, supports their position of guilty. And when the defense argues, they will point to the evidence in the law that supports their contention that Mr. Reinking is not guilty. Please keep in mind, what the attorneys say to you in opening statements and what they say to you in closing arguments is not evidence. So when we start this trial, please, on your notebooks, you can take notes about what they say, but anytime the attorney is speaking directly to you, make a note that that's the attorney speaking and don't get it confused with the evidence in this trial, because what they say is not evidence. So, and I'll give you a charge on all of that as well, but I just want to make it clear that you need to note when you're taking down anything you say, that if it's the attorneys, it's just to help you better understand something, and it's not evidence in the trial of this particular case. But during the closing arguments, the state's attorney will argue first. Defense counsel will be given an opportunity to argue their case, and the state will be given the last opportunity to address you in the closing arguments. Once the arguments have been completed in this case, then it is my duty to read to you all the law that applies to this case, and which will be contained in the jury charge. I am required to read that to you in open court in the presence of all the parties. You will have a copy of that jury charge. Can't finalize the jury charge until all the evidence in the case has been submitted, so I don't know exactly how long it'd be. My guesstimate right now is it'll take maybe an hour and a half or so to read to you, and it's not necessarily a fun-filled, exciting read, but it is absolutely vital, because you can't render any verdicts without knowing the law that applies to the facts in order to accomplish that. You will have a copy of it. You will be allowed to take that jury charge, each of you, back to the jury room for your use during your deliberations. So you're going to have a lot of law thrown at you in a very short period of time, and obviously you'll have the benefit of the written jury charge that you can go through it as you address each count of the indictment. All right? Once the case is submitted to you, you take over the responsibility of determining guilt or innocence as to each of the 16 counts. As I indicated to you last week, if you find that Mr. Reinking is guilty of one or more of the accounts of first-degree murder, then we will have a separate hearing for you to determine whether or not his punishment should be life in the penitentiary with parole or without parole. And so we will have another hearing. There will be additional testimony at that time. The procedure is the same as in the trial, with the state putting on proof first and the defense putting on proof, and the same procedure for direct and cross-examination, so on and so forth. You'll be given there'll be additional arguments, open statements. You'll be given additional charge by the court as it relates to that phase of the trial. Usually, that phase of the trial is not necessarily that lengthy, oftentimes in a day, maybe because of the number of alleged victims in this case. It could be more, but usually within a day. But I just be prepared for it in the event that we have to get to that phase of the trial. A couple other things I want to go over with you, and some of this was briefly mentioned the other day, and just some other fundamental. One other thing I do want to mention, regardless of the fact that the defense has the responsibility to establish by clear and convincing evidence, if they pursue an insanity defense, that they have a responsibility to establish by clear and convincing evidence that Mr. Reinking was insane at the time of these offenses. Mr. Reinking himself does not have to testify, okay? Under the law and under our Constitution, if Mr. Reinking chooses to testify during the course of this trial, he has an absolute right to do so, and his testimony would be evaluated the same as you would the testimony of any other witness in terms of credibility and things of this nature. And I'm going to give you a lengthy instruction on how you might go about considering and weighing the credibility of witnesses and expert witnesses and things of this nature. But my point is, he has an absolute right to testify if he chooses to. However, he also has an absolute right not to testify if he chooses not to do so. And if Mr. Reinking does not testify during the course of this trial, the fact that he did not testify cannot be considered by you or used by you in any manner whatsoever on the issue of his guilt or innocence. It's a non-factor. So, for example, if you go back there or during your deliberations in the guilt phase of the trial, and Mr. Reinking has not testified, you cannot speculate as to why he did not testify. You cannot speculate by his failure to testify. The evidence would have been against him or anything of this nature. It is a non-factor that cannot be brought up, discussed, or otherwise considered by you, even in your own mind privately, on the issue of whether or not he is guilty of any one or more of the offenses with which he is charged. It is absolutely something that cannot be considered by you for any purpose whatsoever. A few evidentiary matters and other procedural things. During the course of this trial, and this was referenced briefly last week as well, during the course of this trial, you're going to hear both circumstantial evidence and direct evidence. Direct evidence is evidence that proves a fact and issue without any inference or presumption. And I'm going to give you a simple example, very elementary example of both of these in a minute. But an issue, fact and issue, usually involves either the elements of the crime, or, in the case of the defense, if he pleads insanity, on the issue of insanity. Those are the facts and issues. There's going to be a lot of facts that you may not resolve, such as what he was wearing at the time of these events, things of that nature. Those things do not address the facts of the issue. So it's the direct evidence is things that people see, hear, smell, touch, whatever the case may be. It's the use of their direct senses. It proves something, and you don't need to look anywhere else to establish that fact if you believe that fact to be true. Circumstantial evidence is all other evidence that does not directly prove a fact and issue, but when considered with all of the other facts, you can reasonably conclude that a fact and issue either occurred or did not occur. Again, I'm going to give you a very elementary type example of this. Let's assume that you were at your home. You were at your home with your one child or grandchild. There's no one else in the house. The doors are locked. No one can get into the house. The pets have been booted out except for the goldfish. All right? And you were sitting in the kitchen with your child or grandchild, and you're baking a batch of cookies, and you're having just a wonderful conversation with your grandchild about how they still liking their new toys from the Christmas. And, you know, before we know it, spring break will be up here. But anyway, you're just having a wonderful conversation with your child or grandchild. You pull the cookies out of the oven and you set them on the counter close to where the child is. You tell the child, do not eat any of those cookies. Then you turn around and you start washing the dishes. All of a sudden you notice that the conversation has come to a screeching halt, so you turn around and see what's happening. Lo and behold, there's a child sticking a cookie in his or her mouth. Okay, you seeing the child eat that cookie is direct evidence that the child ate the cookie. If the child were charged with disobeying a lawful order not to eat a cookie, and the child was on trial for that, and you got on the stand and testified to what you saw, if the jury believed what you saw, they would not have to look anywhere else for the state to establish beyond a reasonable doubt that the lawful order was given and the lawful order was disobeyed. That's direct evidence. You take that same fact scenario, but instead of turning around to wash the dishes, you leave the room. And when you come back into the kitchen, you notice that there's 10 cookies rather than 12. You notice that the child has cookie crumbs on his or her mouth and his or her lap and around his or her feet, and a big, huge smile on his or her face. You didn't see the child eat the cookie, but when you take all of these different individual facts and put them together, you can reasonably conclude that what happened is the child must have eaten the cookie, because there was no one else in the house, including the pets. The doors were locked. They were still locked when you came back into the kitchen, so on and so forth. The cookie crumbs and everything else, and more importantly, maybe the big smile. Who knows? But whatever the case is, you can take all that evidence together and make that reasonable conclusion. That is circumstantial evidence. The important thing that you need to understand is that both evidence are to be treated however you wish to treat it. One's not better than the other. Direct evidence is not better than circumstantial evidence, and the other way around. How you want to weigh that, you have to weigh all of the evidence, direct and circumstantial, but you will decide what weight you want to give any evidence that you hear. Also during this trial, you're likely to hear objections by one side or the other. During the course of this particular trial, when an attorney makes an objection, they are basically telling the court, Judge, I do not believe that the evidence that is likely to be given as a result of that question is admissible under our rules of evidence in the state of Tennessee. When that happens, first of all, don't think anything bad about the attorney who made the objection. They are not trying to prevent you from hearing evidence in this case. They are trying to prevent you from hearing evidence that under our laws is not admissible because it's either not relevant, it's not reliable. There's a lot of different reasons evidence may not be admissible. Okay, so the only thing the attorney is doing when they make that objection is his or her job. Likewise, don't think anything bad about the attorney who asked the question. That attorney's not trying to pull some wool over people's eyes and slip in evidence that they know is not admissible. But in reality, while our rules of evidence may only be typewritten 20 to 25 pages long, the interpretation of those rules go into thousands of pages. I mean, books upon books are written about how our courts have interpreted those rules over the years. The reason for that is that the rules of evidence that we have in the state of Tennessee apply in every single court in the state of Tennessee, whether it be a civil case, a criminal case, a domestic case, whatever it may be. In all 95 counties, we use the same rules to best ensure that all court proceedings are fair and considered equally, regardless of where you are in the state or the type of proceeding. So the reality of it is that we could have a trial going on next door in Judge Watkins' court, and certain evidence is attempted to be introduced in his court that would be admissible, which in this case would not be admissible. You have to look at the individual facts, so the rules are written in a manner that are very prophylactic to allow them to be adapted in a manner that guarantees or best guarantees a fairness within the trial that's going on at that particular moment. So don't think anything bad about any objections that are made. Also, you are to place no weight whatsoever on whatever ruling I make. I am the judge of the law during the course of this trial, so when these legal issues come up, which the objections are, when those issues come up, I will address those issues. And don't think anything about my ruling. Whatever my ruling on a particular matter is not any indication of what my feelings about this case are. I will tell you now, and I have no feelings about this case. It's not my responsibility to think one way or the other about this case. If I started doing that, I couldn't do my job and be fair and impartial. We'll remain open-minded and deal with things as they come along. So please don't read anything into whatever I say or rule or anything else. You are the ones that are going to have to determine what weight, if any, to give to the evidence that you do here. You're locked up, so you're kind of under strict rules. We are going to try to start as best as possible every morning at 8:30 and go until 6 p.m. We will have a mid-morning recess, we'll have a mid-afternoon recess, and we'll have an hour for lunch. Your hour for lunch will be provided to you in the jury deliberation room. If you want to go out and get some fresh air, we will escort you. My staff will escort you out the parking, the garage, the secured garage door to this building. Give you an opportunity to look over the beautiful blue waters of the Cumberland River. But just to get some fresh air, I know, because y'all are going to be locked up a whole lot of the time. During lunch, I will mention to you, we're trying to put together some things for you to do on Sunday when you don't have anything to do. We're going to have kind of a checklist and see if we can come up with some kind of mutual agreement on what to do, and if not, we'll go by the majority. But it'll give you a little exercise of what ultimately you're going to be dealing with during the course of this trial. Again, I will do everything possible to keep this trial moving so as not to impose any more on your time than is already going to be required in order to try this particular case. Is there anything else from the state? Anything from the defense?
No, sir.
All right, in that case, ready to read the indictment?
This board comes to the jury. The indictment in this case reads as follows. State of Tennessee, Davidson County, count one. Grand jurors of Davidson County, Tennessee, duly appointed and sworn upon their oath present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the finding of this indictment, unlawfully, intentionally, and with premeditation, did kill Joe Rene Perez, Jr. in violation of Tennessee Code Annotated Section 39-13-202 and against the peace and dignity of the state of Tennessee. Count two. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the finding of this indictment, unlawfully, intentionally, and with premeditation, did kill Taurean Charles Sanderlin in violation of Tennessee Code Annotated Section 39-13-202 and against the peace and dignity of the state of Tennessee. Count three. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the finding of this indictment, unlawfully, intentionally, and with premeditation, did kill Akilah Dasilva in violation of Tennessee Code Annotated Section 39-13-202 and against the peace and dignity of the state of Tennessee. Count four. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the finding of this indictment, unlawfully, intentionally, and with premeditation, did kill DeEbony Groves in violation of Tennessee Code Annotated Section 39-13-202 and against the peace and dignity of the state of Tennessee. Count five. Grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the finding of this indictment, did attempt to commit the offense of first-degree murder as defined in Tennessee Code Annotated Section 39-13-202 in that he the said Travis J. Reinking did intentionally and with premeditation attempt to kill Shanita Waggoner, and Shanita Waggoner suffered serious bodily injury in violation of Tennessee Code Annotated Section 39-12-101 and against the peace and dignity of the state of Tennessee. Count 6, the grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the filing of this indictment, did knowingly employ a firearm during the commission of or attempt to commit a dangerous felony, to wit, attempt to commit first-degree murder of Shanita Waggoner in violation of Tennessee Code Annotated Section 39-17-1324B, and against the peace and dignity of the state of Tennessee. Count 7. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the filing of this indictment, did attempt to commit the offense of first-degree murder as defined in Tennessee Code Annotated Section 39-13-202, in that he, the said Travis J. Reinking, did intentionally and with premeditation attempt to kill Sharita Henderson, and Sharita Henderson suffered serious bodily injury in violation of Tennessee Code Annotated Section 39-12-101 and against the peace and dignity of the state of Tennessee. Count 8. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the filing of this indictment, did knowingly employ a firearm during the commission of or attempt to commit a dangerous felony, to wit, attempt to commit first-degree murder of Sharita Henderson in violation of Tennessee Code Annotated Section 39-17-1324B, and against the peace and dignity of the state of Tennessee. Count 9. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the filing of this indictment, did attempt to commit the offense of first-degree murder as defined in Tennessee Code Annotated Section 39-13-202, in that he, the said Travis J. Reinking, did intentionally and with premeditation attempt to kill Akilah Shaw in violation of Tennessee Code Annotated Section 39-12-101 and against the peace and dignity of the state of Tennessee. Count 10. Grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the filing of this indictment, did knowingly employ a firearm during the commission of or attempt to commit a dangerous felony, to wit, attempt to commit first-degree murder of Akilah Shaw in violation of Tennessee Code Annotated Section 39-17-1324B, and against the peace and dignity of the state of Tennessee. Count 11. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the filing of this indictment, did attempt to commit the offense of first-degree murder as defined in Tennessee Code Annotated Section 39-13-202, in that he, the said Travis J. Reinking, did intentionally and with premeditation attempt to kill James E. Shaw, Jr. in violation of Tennessee Code Annotated Section 39-12-101 and against the peace and dignity of the state of Tennessee. Count 12. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the filing of this indictment, did knowingly employ a firearm during the commission of or attempt to commit a dangerous felony, to wit, attempt to commit first-degree murder of James E. Shaw, Jr. in violation of Tennessee Code Annotated Section 39-17-1324B, and against the peace and dignity of the state of Tennessee. Count 13. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the finding of this indictment, did kill Joe Rene Perez Jr. during the perpetration of or attempt to perpetrate first-degree murder in violation of Tennessee Code Annotated Section 39-13-202 and against the peace and dignity of the state of Tennessee. Count 14. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the finding of this indictment, did kill Taurean Charles Sanderlin during the perpetration of or attempt to perpetrate first-degree murder in violation of Tennessee Code Annotated Section 39-13-202 and against the peace and dignity of the state of Tennessee. Count 15. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the finding of this indictment, did kill Akilah Dasilva during the perpetration of or attempt to perpetrate first-degree murder in violation of Tennessee Code Annotated Section 39-13-202 and against the peace and dignity of the state of Tennessee. Lastly, count 16. The grand jurors of Davidson County, Tennessee, duly impaneled and sworn upon their oath, present that Travis J. Reinking on the 22nd day of April 2018 in Davidson County, Tennessee, and before the finding of this indictment, did kill DeEbony Groves during the perpetration of or attempt to perpetrate first-degree murder in violation of Tennessee Code Annotated Section 39-13-202 and against the peace and dignity of the state of Tennessee. Signed, Glenn R. Funk, District Attorney General of the 20th Judicial District. Signed as a true bill by the then foreperson of the grand jury and filed with the Davidson County Criminal Court Clerk on February the 1st, 2019.
And to the 16 counts of the indictment, how does Mr. Reinking plead?
Your Honor, Mr. Reinking pleads not guilty by reason of insanity.
All right. Members of the jury, you've heard the indictment read. The formal plea is not guilty by reason of insanity entered in this case. As a reminder, I will tell you that the indictment is not evidence against Mr. Reinking and cannot be considered or used against him in any manner whatsoever. It is simply the formal written instrument that brings him into this courtroom and places him on notice as to why he is even in this courtroom. Ready to proceed with opening statements?
Yes, Your Honor. No one was expecting it.